Welcome to the Bloomberg Law Bankruptcy Review. I'm Lee Pacchia. I'm joined now by Bloomberg News editor-at-large and bankruptcy columnist Bill Rochelle. Welcome. So you came back. You did not ride off into the Texas sunset. You were just on vacation. Welcome back.
Well, thank you. I tried to stay away as long as I could, but, you know,
that's life.
Turn into a pumpkin sometime.
All right, so we have two items to run through today, and wouldn't you know it, it's a new month, new page on the calendar, and we have a new bankruptcy case to talk about. It's not a pre-pack. It's of decent size. It's called NewPage. Tell us about it.
You're right. You know, it's like you flip a switch when September comes, and suddenly you're back in business with a nice new case. NewPage is the largest maker of coated paper in North America. Big company. It is a train wreck resulting from a 2005 acquisition by none other than Cerberus. The case looks like it's going to be pretty interesting because so far as anybody can see right now publicly, there's nothing lined up where anybody in particular is going to buy the thing or convert that to equity or Lord knows what. So here is roughly, Lee, what the situation looks like. In addition to a revolving credit, there's about $1.8 billion in first lien debt. And that paper around the time of filing and just after was trading in the high 80s. So that sounds like, you know, maybe those folks ain't going to hurt too much. On the other hand, the second lien debt, and if memory serves correct, that's about $800 million. That's in the low teens. So that's a low enough number where it's, you know, arguable both ways, that they either are entitled to something or nothing at all. And then, of course, lower than whale doo-doo, you have some $700 million in unsecured debt, and God knows if those folks are going to be able to come out with anything. So this looks like it could be a really fun case because assuming nobody has gobbled up enough of the debt at the various different levels to control the whole cotton-picking case, this could be one of those classic fights where there is a big dispute over what valuation is and over whether anybody besides the first lien creditors are entitled to get anything, and if so, how much. So I'm sort of hoping we finally have a fun case.
Right, an old-fashioned Chapter 11.
That's right.
And we also have a major decision coming down in one of the Madoff proceedings. It doesn't directly talk about the owners of the New York Mets, but it sure does affect them in the end.
Boy, howdy, you can say that. I mean, Fred Wilpon, the owners of the Mets, are sitting there rolling around right now saying, oh my goodness.
They've had a rough month.
We lost a big case and we weren't even a party to it. Now, here's what the deal is. I mean, ordinarily, Lee, of course, when you have a judge on one level decide something, the only other judge who's going to disagree will be a judge at a higher level. Well, that's not what exactly is happening here in the Madoff case, because the Madoff trustee started about 1,000 lawsuits, huge number of lawsuits, and some of them are wending their way at different issues to the district court. Now, right now, Mr. Wilpon and the other owners of the Mets have a motion that they argued before District Judge Jed Rakoff in August, where they want most or all of the trustees' lawsuit dismissed. Meanwhile, a similar case was before another district judge named Kimball Wood, who wrote an opinion just in early September saying, no, the trustees' complaint passes muster at the early stages of a case. Now, if you sit and look at the complaints in the Wilpon on the one hand and in Kimball Wood's case in the other, which involves a chap named Ezra Merkin, you say to yourself, well, look, if the Merkin complaint is good and it's not going to be dismissed, the same ought to be the result for the Rakoff case involving the Mets owners. But of course, the way the rules work in federal court, the fact that one federal district judge rules one way does not mean another federal district judge has got to rule the same way. So theoretically, we have the possibility that two different district judges, both of them senior, very respected district judges, could possibly disagree with one another. On the other hand, I wonder how Judge Rakoff feels, because here he is sitting here right now saying that to himself, if I'm going to rule differently from Kimball Wood, one of the two of us is wrong, and am I going to embarrass myself or am I going to embarrass her? So this is really unusual. You just almost never see a situation in federal litigation where you have two district judges deciding pretty much the same issues at the same time. don't happen. And I can't wait to see how this turns out. We're going to know because Rakoff said he's going to decide his case by the end of September. So if he rules any differently, he's going to have to write himself one crackerjack opinion explaining why he has a difference of opinion with District Judge Wood.
Right. It's an interesting dynamic between the two judges, but it also has an impact on the mediation proceedings that we're currently seeing between the trustee Picard and the owners of the Mets. That's got to change the picture, right?
Thank you for mentioning that, because many of these are in mediation right now, especially the Wilpon case. So if you lose a motion to dismiss, that's bad news, because it means that the price to settle goes way up. I wrote a story before I went on vacation figuring that the minimum that the trustee for Madoff will settle with Wilpon for is about $300 million. So, if he gets another opinion under his belt saying he has a claim that's good enough to go to trial, well, then the settlement number only goes farther north, maybe a lot farther north.
Interesting stuff. Let's leave it there for now. Bill, thanks so much for coming in. Good to see you. That's Bloomberg News bankruptcy columnist Bill Rochelle. For more bankruptcy law and news, log on to BloombergLaw.com. I'm Lee Pacchia. Thanks for watching.